Okay, good afternoon, everyone. Good afternoon. Thank you so much for joining us today. On behalf of IP Osgoode and Osgoode Hall Law School, I'd like to welcome you to the IP Osgoode Speaks speaker series. Now, you may have noticed there's lots going on in the law school today, but the fact that you're here, you're actually in the right room. This is going to be a great event, and I'm very looking forward to today's speaker that we have. I'm Professor D'Agostino, and I'm the founder and director of IP Osgoode. Now, if you haven't already gone on the website, I'd really encourage you to do so. In fact, make it your homepage. There's lots of stuff going on the website, all fun and up-to-the-minute information on all that is exciting in IP here in Canada and around the world. And in fact, the conversation will continue beyond today. Where is Joseph Turcotte? Joseph Turcotte. Hello, Joseph. He will be blogging on today's event, so that post will be up in a few days' time, so you can feel free to comment and the conversation continues there. I also encourage you to tweet away. I know that some of you have already been tweeting on today's event, and we have right here on the whiteboard at Ipilog, hashtag IPOsSpeaks. So feel free to use that as much as possible. Now, today's event, of course, is possible due to the generous support of our founding law firm sponsors, and I'd like to acknowledge Castles, Gowlings, and McCarthy's. I'd also like to acknowledge our new Associate Dean, Professor Karis Craig, who is the Associate Dean of Research here at Osgoode, and we thank her for her generous support, and she's also an IP expert in her own right. So thank you, Professor Craig. Now, of course, events of this caliber are not possible without also the entire logistical team, and I see Michelle Lee there standing by the food, which I hope you've already had some samples of. She's been great with Mary Barbieri. So Michelle, of course, is the assistant director of IP Osgoode and works closely with Mary and the entire team of students that I see sprinkled around the room. So thank you very much, and I'd like to give a round of applause to Michelle Lee, Professor Craig, and all our sponsors. Now, as many of you know, IP Osgoode aims to inject many more and new voices to the IP debate here in Canada and around the world. And we do so really by looking to also our students to enhance their learning opportunities. And I see some of our IP-intensive students around the room. And what we really aim to do is to build closer bridges in the IP community here in Canada and around the world, and today's event is no exception. Now, I'm very pleased to welcome our guest speaker, Dr. Emily Hudson. So Dr. Hudson, she joins us from the University of Oxford, and I'm very pleased, my DPhil alma mater, and I had the good fortune of meeting her last year. So I'm really pleased that we already got her here just a year of knowing each other. Now, Emily joined the University of Oxford in 2012, and there she is a career development fellow and is also associated with St. Peter's College. Now, I don't know if you're familiar with the college system at Oxford. There are many colleges, but I can assure you that St. Peter's College is the best one. And no bias, of course. So Emily is quite busy at Oxford. There she serves as the academic member of the Oxford Intellectual Property Research Centre, affectionately known as OIPRC, something Professor Weaver knows a thing or two about. Emily also served there as acting director, and she's also the chair of the Oxford International Intellectual Property Moot. In fact, I saw an announcement go out. So for all of you who are with students or teaching students or know anyone who wants to participate, I do encourage you to participate in this first caliber moot in IP at Oxford. Now, she works in all different areas, and also beyond her work in IP, she works in the areas of personal property law as it relates to cultural institutions and art. And if you've walked across the building today, you've seen a lot of art coming into Osgoode. So I do encourage you to take a little tour after today's class as well. Now, she's previously worked at the University of Queensland and the University of Melbourne, and for 3 years was a solicitor at Minter Ellison Lawyers. She still maintains an association with University of Queensland as a senior lecturer. And she's very studied, holds undergraduate law and graduate degrees from the University of Melbourne. Her doctoral thesis uses empirical techniques to analyze how cultural institutions here in the US, in Canada and Australia understand and apply exceptions to copyright infringement, something we've been learning a lot about with the last onslaught of copyright reform here in Canada. And Emily's thesis has won 2 prizes already at the University of Melbourne, and I can assure you there are many more coming her way, especially after her book is published from Cambridge University Press. So I would look out for that, and we'll be sure to post it also on the IP Osgoode site. Now, Emily will be presenting on a very hot topic and in copyright. So what's the hottest topic in copyright right now? Well, it's no doubt drawing also from her doctoral work, and that's dealing with copyright exceptions as user rights, an empirical critique. Now, we've asked Emily to speak for about 45 minutes, after which point we look forward to your comments and questions and to have a healthy discussion. So with that, I pass the floor on to Dr. Emily Hudson.
Thank you. Thank you. So I'm very excited. I've presented this work in a number of different fora, but this is the first time I've spoken about Canadian copyright law to Canadians. So just like you coming to Melbourne to teach us how to eat Vegemite properly might be something which is a risky proposition, I've taken on the challenge of coming to Canada to talk in part about Canadian law, in fact a great deal, but I'm also going to talk about US law and Australian law as well. So the sort of broad aim of my presentation today is to ask some questions about one of the central ideas in the CCH decision, which is this idea that exceptions are users' rights. Now, I want to explore this idea not by reference to some abstract, high-level theorising about whether such a proposition is open as a matter of theory or doctrine. As someone who's concerned about what I see as the at times unprincipled expansion of copyright, I support a meaningful role for exceptions and, by and large, support the approach of the Supreme Court in CCH. However, I'd like to focus on how users conceive of copyright and copyright exceptions. So the particular user constituency that I've focused on in my PhD and my research has been cultural institutions, including institutions located at universities. So academic libraries are within the ambit of my research. That said, although today I'm going to talk about cultural institutions, I think some of the broader themes apply to other users and copyright stakeholders. One of the key propositions I'm going to make today is that analysis of the operation of exceptions, and indeed copyright law, often draws heavily and too heavily on the law in books. So a lot of academic scholarship tends to focus on the words of copyright statutes and instruments to develop an idea of what the law says. And from this analysis of the instruments, case law and so forth, it develops a picture of what this then means for copyright users and stakeholders. In contrast, the behaviour of those who are regulated by the law is often ad hoc and impressionistic, rather than the result of any systematic empirical analysis. So now this is not to say, to be clear, this is not to say that copyright scholars are not interested in real-world issues in relation to copyright, but rather that they've lavished far more attention on doctrinal matters than on empirical matters. So do copyright stakeholders understand and apply the law in the same way as predicted by doctrinal analysis? Because if the answer to this question is no, then much analysis of the need for law reform and how any new or revised provisions ought to be drafted may be ineffective and may have many unintended consequences. Now, I don't want to dwell on CCH for too long, but I think it's really crucial that I emphasise some key aspects, more so in the history of the case, because it will contextualise some of my later propositions. So, 1993 is a starting point for my short history. So that's when we have the proceedings instituted against the Law Society. At that point, some 5 years had elapsed since the Phase 1 copyright reforms, and these amendments have been debated, I should say, for many years. And in the first phase focused more on rights and administration of rights, and included revision of the legislative framework in relation to collective administration, and this really permitted an explosion, one might say, in the number and the activities of collectives. Following on from the first phase, there was a second phase of copyright reform, but by 1993 this was just a glimmer in the legislature's eyes, because it wasn't until 1997 that Phase 2 gets passed. These Phase 2 amendments included new provisions, specific exceptions directed to libraries, archives and museums, the LAM or LAM provisions. They don't come into force though until 1 September 1999. So, back to 1993, and the publisher's complaint had two main parts, as you will recall. One in relation to the self-serve photocopiers at the library, so an authorisation-based action, and the second in relation to the custom photocopying service, which is the library itself making the reproductions, and the claim is for direct infringement. Now, assuming that the reproduced materials were protected by copyright and that there was actually an infringing act, the library had two broad options for how to deal with this copyright issue. So one is through a voluntary licensing strategy. At this point in time, CanCopy, the newly established collective for administering rights in published print materials, was negotiating with libraries for the first suite of blanket licenses, although the legal publishers didn't join until 1996. So at the point in time in which proceedings in CCH were instituted, there was no blanket licence available, to my knowledge. If somebody has different information, I'd be eager to hear it. That said, you still could have had individual licensing. The library could, in theory, have gone to individual publishers to clear rights. But they went with a second option, which was fair dealing. So there was an access to the law policy, which included various limbs. So for instance, in relation to only single copies being provided, that the purpose of the person making the request needed to be research, review, private study, criticism or use in court. There were quantitative limits on the amount of material supplied, so 5% was supplied without additional review, over 5%, and the request went through an additional review process. And the cost, the fee that was charged was calculated on a cost recovery basis. So, fair dealing had been a statutory provision in Canadian law since the country's first comprehensive statute, copyright statute. But even though it had been in the legislation for a long time, for much of that there was very little case law considering fair dealing. But to the extent there was an understanding of what fair dealing meant, I think during the 1990s the accepted view seemed to be, amongst many people, that fair dealing applied in narrow circumstances. So for instance, amongst participants in my field work who were involved with negotiations in relation to the first CanCopy licences in the early 1990s, people said that the understanding was that a work was infringed by reproducing 2% of it or even a single page. The understanding was that fair dealing only operated in fairly narrow circumstances. The trial decision in CCH came down in November 1999, so that's 2 months after the LAM provisions came into force. The publishers were successful in showing infringement of some of the legal materials copied by the library under its custom photocopying service. And Justice Gibson made findings on fair dealing that echoed much of the prevailing understandings about exceptions. He said that fair dealing should be strictly construed and that the activities of the library were not performed in relation to its own research, private study, criticism or review. We then get appeals to the Court of Appeal and then subsequently to the Supreme Court. This is a point at which I want to move fast because I think these themes should be fairly well known to all of you. So by the time we're in the Supreme Court, 3 main legal issues: originality, authorisation, fair dealing. What does the Supreme Court say in relation to fair dealing? It's that there's a commentary on the dual objectives approach to copyright and the invocation of users' rights language, acceptance of a large and liberal definition of research, which permitted the Supreme Court to find that it included commercial activities, first of all, but also that the library could take the benefit of the client's research purpose, because there was a broader research process, I should say, in which the library engaged. 6 fairness factors. This should all be revision, I hope, following on from the Court of Appeal's decision, and a finding that fair dealing was in addition to the LAM provisions. So, in terms of the subsequent cases, and again I'll move through this relatively quickly, my sense of the subsequent cases were they really confirmed the status of CCH as a landmark case that changed the copyright landscape. Bear in mind, and the asterisk is important, what I'm going to say now is based on what was happening around 2008, and this is important for the timing for my field work. So this is as at 2008. But you have a number of cases to apply various dicta from CCH, including its statements on the philosophy of copyright. And at that time too, the Copyright Board had released its decision in the Tariff 22A litigation. So this was the long-standing litigation by SOCAN to set tariffs for the online communication of music for the period 1996 to 2006, and the Copyright Board, of its own volition, considered whether fair dealing might apply to previews of works. So those are the snippets you listen to when you're deciding whether or not you want to purchase or download a track, and the board said that this fell within fair dealing. And this, I think, was significant for my research for a number of reasons. First of all, the board took seriously the idea that research should be given a large and liberal interpretation. Took seriously that idea. So it was not fatal, for instance, that the music sites were not conducting research, that they were facilitating the research of others. Secondly, and very importantly, the acts were not in relation, the acts were not only in relation to a non-scholarly form of research, so consumer research, but they did not relate to scholarly or literary works. And the reason why that's significant is a lot of the fair dealing case law to consider research has involved things like examination papers and study notes, which may suggest that fair dealing was really just about academic pursuits with thick books with big words. And what the Copyright Board was saying was that this was not the case. It can involve it can involve different sorts of materials in a non-scholarly setting. Thirdly, and I think a third reason why Tariff 22A was significant, was it moved the relevant facts involved works being transmitted online to an effectively unlimited audience of people. And this was nevertheless not fatal to there being fair dealing, to a finding of fair dealing, I should say, because of the amount extracted, because of the lack of competition between the snippets with full copies purchased for repeat listening. So even though CCH involved analogue world of library photocopying and very much a point-to-point dispatching of single copies, the Copyright Board clearly did not consider the reasoning in CCH was limited to its own facts. So, key point in terms of the subsequent cases is that the way in which those cases treated CCH seemed to confirm its status as the most important case to have been handed down by a Canadian court. The academic response, overwhelmingly, although not exclusively positive. Just a few themes I've taken out in this slide of the sort of ideas that appeared in this literature, but for many commentators the use of users' rights language was highly significant because it was said to reconceptualise the role of exceptions in copyright law. Geist said the case instantly ranks as one of the strongest pro-users' rights decisions from any high court in the world. Flexibility was also seen to be important, that CCH had injected much needed flexibility into the law of fair dealing through the interpretation given to the research and through the fairness factors. This was seen to breathe new life into fair dealing. Drassenauer said CCH is rightly and widely regarded as bringing forth a truly fundamental shift in the way Canadian copyright law is to be understood and practiced. There were comparisons undertaken with other jurisdictions in which Canada fared extremely favourably in comparison to such places as the United States, boo, and the United Kingdom. Okay, I'll accept that. So the academic commentary, again, very positive and suggesting meaningful change to come from this decision. So, when I started my fieldwork in Canada in 2008, this was the backdrop. This was the backdrop. Fundamental alteration in the philosophy and practice of copyright. In terms of my fieldwork methodology, what I've been doing for the last 10 years is semi-structured interviews with staff of cultural institutions and of people at other entities, so rights holder representatives, collective societies, industry, peak bodies and so forth. Participating institutions tend to be large national and state or provincial level institutions. So I'm looking at leading institutions in the sector. Leading institutions to me were more interesting because they're, first of all, more likely to be at the forefront of changing policy and practice in the sector, but also the people who I spoke to tended to have a clear idea of where their practice fitted in with those of equivalent institutions, so I was indirectly able to learn more about the sector. Interviewees were staff whose responsibilities include copyright. At some institutions I spoke with more than one person, as you can see from the numbers of interviewees compared with institutions. And the questions were not just about exceptions, they were about copyright management and digitisation more broadly. So I was asking a range of questions about how copyright was managed in relation to various activities, so internal management, preservation, user request, exhibition and on-site access, and then online access as well. And in Canada, a subset of questions related to fair dealing and CCH. Just want to make one thing clear. This was not intended to be a survey of practices, though I think I got a good sense of practices across the sector. It wasn't quantitative, wasn't intended to be a survey, but qualitative research. So, I conducted my research in Canada immediately after having performed equivalent work in the US. And it quickly became apparent to me that the experiences of institutions were very different from that in the case law and commentary. One of my first surprises, I'm going to tell a little anecdote here related to self-serve photocopying. Now, many of you will be aware of an Australian case called Morehouse and the University of New South Wales, a test case brought in the 1970s in relation to self-serve photocopying equipment in academic libraries. And in 1975, the High Court held that the university was liable in relation to its photocopying equipment. So the opposite result from CCH, okay? But there was a legislative response to Morehouse, the so-called Section 39A notice. So this is my overview of what a Section 39A notice does, and the effect in practice has been to undo the outcome in Morehouse. So if libraries place this notice on or near equipment, photocopiers, computers, now other things that they supply, they will not be liable for authorising copyright infringement by reason only that they supplied the equipment. It continues. What does the notice say? Here is my summary of what it says, but most relevant for our purposes is the third bullet point, because it talks about what fair dealing is. And the Australian Copyright Act states that certain dealings undertaken for research or study purposes, are deemed to be fair. So in Australia, this is often known as the 10% rule, because 10% serves as the quantitative limit for this deeming provision. So you copy up to 10% of the number of pages or total number of words. That's deemed to be fair. Do not pass go, do not collect $200. It's deemed. But more extensive copying can still be a fair dealing. It's just that you need to go through the case-by-case analysis. Okay? This is what I grew up with. Now, you can imagine my shock when I was doing some fair dealing at one of your libraries and the equivalent sign was not issued pursuant to statute, but was issued by Access Copyright, yes, and had on it fairly similar numbers in terms of how much could be copied, but it was all done pursuant to a licence. And I thought, this is insane. Hang on a moment, I'm in the country with the most forward-leaning fair dealing decision in the world, and you guys are paying for things that are deemed to be fair dealing in Australian law. So this was literally the first kind of, my first exposure to the way in which the law that I've read about in the academic commentary and the case law and the practice wasn't quite as aligned as I had expected. And as I continued my research, I observed that amongst those participating in my project, the CCH decision had yet to have any meaningful impact on behaviour. Most interviewees reported a conservative approach to copyright management, and knowledge of CCH and the law were mixed, with numerous interviewees knowing very little about fair dealing, let alone CCH. So just to give you a sense of some of that research, in terms of libraries with user request, there were some academic libraries that had moved to electronic delivery of documents in response to user request. And they were doing this in reliance on CCH. And when I did this study, it was about 20 to 30% was the estimate given by one interviewee who was in the know, which is why I've quoted him. About 20 to 30% of universities had moved to electronic delivery in reliance on CCH. At that stage, a handful of universities were referring to fair dealing and CCH in policies regarding e-reserves, although at the time this seemed to be a very limited group of universities, and there wasn't at that stage much momentum to change position. Well, let's put it this way, interviewees were not happy with the situation, but their institutions were not looking to change position anytime soon. In terms of public libraries and special collections, there were reports that researcher requests would be fulfilled pursuant to a fair dealing analysis, although CCH didn't change this. So this was an existing practice that CCH did not influence, but it supported, but did not influence it. But as soon as you went to any of the sort of creation of digital and online resources, the approach was very much focus on public domain material, focus on things where you've readily got licenses and assignments of copyright in place, don't rely on fair dealing or any exceptions. They're just not relevant to this particular suite of activities. Archives and museums. Again, I'll just say a few words about user request. So some participants, there was a fairly disparate practice in relation to user requests. So some institutions would fulfill researcher requests without clearance, including via electronic delivery, this thing that some of these wild and crazy academic libraries were now moving to do following CCH. Well, some of their museum and archival friends were already doing this, but not because of CCH. I mean, some of them had heard of fair dealing, but some of them, it really varied. Some had heard of fair dealing, had heard of CCH, others hadn't. There were some participants amongst the archives and the museums who required clearances for all requests, even researcher requests, and for non-research requests-based requests, it was typical to put the onus on the requestor to clear rights, although there was variation as to whether or not the material would be supplied in the interim or whether there would be a requirement that evidence of clearance be shown. And like their friends in the libraries, when it came to any digital and online resources, fair dealing was not seen to be relevant. So, the research highlighted a significant gap between the academic and judicial response to CCH and that of cultural institutions, even though the defendant in CCH was a library. As one interviewee said, there is a real divide between the views of academics at his university and those in the library who must face the music. This raised for me a number of questions. So, will CCH ever have a meaningful impact on cultural institution practices? If so, what needs to happen? What's the relationship between the law and books and the law and action? And this third point too, which I'm going to focus on for a couple of minutes. What does this mean for perennial debates in countries like Australia and Canada about a shift to fair use? I'm not phoning a friend, I'm just checking how much time I have left. I actually already know the answer to that question. It's not polling the audience. So basically, debates about the drafting of exceptions are long-standing in the copyright world, and in countries like Canada and Australia, where I'm originally from, there's been a tendency to follow the British model of lots of specific exceptions, and this has led to a tranche of work asking whether or not we need to find ways to make exceptions more flexible, including possibly through a fair use provision, something open-ended. This interest in a new drafting paradigm in which fair use supplements or replaces detailed exceptions seems to be based around two propositions. First of all, that there are issues with the current system, and secondly, that these issues can only be resolved through a new drafting paradigm. These issues are inevitable under any model which relies upon detailed provisions. So inadequacies in exceptions might relate to such matters of lack of clarity in the language. So more words, just because provisions are detailed doesn't mean they are clear. More words does not equate with clearer meaning. Provisions can become prone to redundancy. So in Australia, the 2006 private copying exception, already redundant because of cloud technology, because of the way it's drafted. Conduct that ought to be covered by an exception might be excluded, and fixing all this requires endless rounds of law reform. So in Australia, it seems like every 3 to 5 years there's another copyright review to consider exceptions. So fair use and its analogues have been identified as a possible panacea to help cure these ills, as it's argued that fair use is just inherently better adapted to deal with the sort of changing norms and technologies and so forth. Now, to be clear, this view is not universally shared. There are many people who are really concerned about fair use, in particular that it's unpredictable, and this unpredictability is then said to create intolerable uncertainty and much greater expense, because you have to go and litigate to find out what the answer is, and that this creates expense for copyright owners and for users as well. So we have a debate which is often presented as one in which the choice is between flexibility and certainty. So flexibility in a fair use or expanded fair dealing world, and certainty of having more detailed exceptions. But one of the ideas that I want to press is actually it's a false dichotomy. Even though there's truth in the idea that standards offer flexibility and rules offer certainty, existing debates have often rested on an oversimplified account of the law and ignored the nuance in how provisions operate in practice. I've used ideas from the legal rulemaking scholarship to make out these claims. So some of you might be familiar with the literature on standards and rules. And it's been said the key difference between a standard and a rule is the degree of precision. So rules utilise more prescriptive language than standards because the rulemaker has specified in advance the legal consequences that flow from particular behaviour. Rules have the effect then of reducing judicial discretion, because once particular findings of fact are made, certain legal consequences will follow. So to illustrate, it's an offence to drive at greater than 60 kilometres an hour down the road, rule. It's an offence to drive at an unreasonable speed, standard. So standards provide guidance rather than a prescriptive rule. One of the key insights of the legal rulemaking literature has been to provide predictions about when it's better to draft law as a rule and when it's better to draft law as a standard. And this is based on various indicia of efficiency. So for instance, when you think about costs of promulgation, standards might be attractive when behaviour is highly variable or subject to frequent change, because it's impossible to draft rules to cover every possible contingency. It might be better to have a standard and turn those questions over to the judge or adjudicator. So in terms of copyright exceptions, just reading them off the statute, which I'm about to tell you is a dangerous idea, but let's just do it for now. Reading them off the statute, fair use looks more like a standard. Libraries and archives provisions often, although not always, look more like rules. Fair dealing, it's somewhere in the spectrum, sort of, I think of it as more of a standard than a rule, but it's definitely more rule-like than fair use in its drafting because it's limited to certain purposes. But that was dangerous. Why was it dangerous? Because there's much more to it. Really, it's the third point I want to focus on in particular. Interpretive practices bear on how, also bear on the law and action and can produce very different outcomes to the law and books. So here's a quote from Cass Sunstein in relation to this idea of the importance of interpretive practices, where he says everything depends on the understandings and practices of the people who interpret the provision. Interpretive practices can convert an apparently rule-like provision into something very unrule-like. It's necessary to see what people take it to be. So, to illustrate, fair use in the US, in my opinion, is a standard with rule-like qualities. So this is the accumulation of judicial precedent, means that there are areas in which fair use law is quite certain. And institutions are quite comfortable in drawing from the case law, and they feel that they feel a real comfort, which you'd normally associate with a rule. 3 copy limitation and preservation copying provisions. So those of you who know libraries and archives provisions, not from this country I might add, may be aware that there's a 3 copy limitation introduced in some statutes. The US has had a 3 copy limitation and preservation copying since the 1976 Act. The Australians put in some new preservation copying provisions in 2006, and for reasons I would struggle to explain, decided to repeat this insane idea and also put in a 3-copy limitation. But it's okay because nobody takes it seriously. 3 sounds like a rule, but what do they read 3 to mean? Reasonable. So you have something that appears to be a rule, operates like a standard. Administrative copying by cultural institutions, an example of where user norms have ousted copyright from consideration. There's various ways in which user behaviour may be quite different from what the law says. Now, this is why it's problematic for any discussion of the drafting of exceptions to focus solely on the law and books, because it misses all this nuance in how the law actually operates in practice. To push this a little bit further in terms of what sort of user behaviours am I talking about, I'm going to do something which I've not done before. Well, I've done it before in Australia, but we're not being compared. So it was there was no problems in doing this in Australia. Nobody felt like they were under attack. But this is some illustrations. I'm going to compare 2 slides comparing US and Canadian law and practice. Now, this is the law slide, and I'm going to put to you the proposition that when you look at the law as a matter of doctrinal analysis, there's a bunch of similarities between Canadian and US law in relation to the 2 equivalent general exceptions, fair use and fair dealing. So in terms of the text, perhaps one of the main differences is closed-ended compared with open-ended list of purposes, but with CCH encouraging a broad interpretation of the purposes, and with the fairness factors, there is a degree of similarity there. You have case law which has some very forward-leaning understandings of fair use and fair dealing. I mean, I would argue that CCH is more forward-leaning than Campbell and Acker-Rose. I think there's some more recent cases that have pushed that sort of fair use argument even further, but there's similarity in forward-leaning cases you could rely upon to give you comfort as an institution that what you're doing is within the bounds of the exception. Academic commentary, vast. This is really an area where lots of people want to write. Overwhelmingly positive response to CCH amongst Canadians, as I said, not exclusively, but overwhelmingly. I think there was I sense more disagreement in US scholars. Some are quite anti-fair use, are really concerned about it. But you know, you've got quite a big body of scholarship from which to draw. And yet, when we come to the experiences, extremely limited reliance on fair dealing in Canada, remember 2008, just want to bear that in mind, in contrast with the US. So, for instance, I wondered whether it would be open to argue under a CCH analysis of fair dealing as informed by Tariff 22A that fair dealing could apply to research-oriented outputs and not merely copies supplied directly by the institution to a user. So this could apply to content in some exhibitions. It could apply to collection databases on public websites that are really being used for research purposes. However, when I did my field work, such arguments were not even being considered by anyone I spoke with, let alone implemented. Now, this may seem like quite a radical interpretation to adopt, and yet in the US at that time, this view that you could use fair use for for online outputs, research databases and so forth, was coalescing as an unremarkable part of fair use practice. So amongst the participants in my research, over half reported that they made available on websites small-scale images of artworks and photographs under a fair use analysis. And there was also reports of institutions making other content available, literary materials, extracts from audio works and so forth. Now, to be clear, this was not a fair use free-for-all. This was quite limited, targeted instances. but it did show this malleability and meaningfulness of fair use for the US participants. So it was invoked for on-site access, exhibition use, preservation copying. And it meant too that in the US, the equivalent libraries and archives provisions don't cover museums and galleries, but that didn't seem to matter because fair use was the preeminent exception. I thought this is not just down to legislative drafting. So when I started to press further some of the similarities and difference between institutional practice and resourcing, this is a summary of some key points comparing, again, the US and Canada. So in terms of the knowledge of interviewees, in general, I thought the US interviewees had greater familiarity with copyright law, had better access to specialist advisors. So whether this was through a centralised unit within the institution itself, or a copyright lawyer or a copyright officer, or just that there was greater engagement amongst staff about copyright. In terms of the risk preferences, institutions almost always say we're conservative. But I thought that the way in which US interviewees spoke about risk had what I would term more of a commercial flavour to it. And so overall, I'll come to some of these points about case law and legislative history in a moment. My sense was there was other things happening in relation to risk management and knowledge and resourcing, and indeed broader cultural and historical factors. I saw, comparing the three countries in my study, some instances in which institution staff have internalised an ethic which results in them being prepared to ignore copyright because they view the particular activity that they're undertaking as more important than the details of the Copyright Act. So collection management is the best example of this. So we're talking about here taking photographs, in particular of artwork and objects, for insurance purposes, to have a copy of the work on a database so that you can track where it is and its condition and various things. Three approaches were quite common. One, we don't think about copyright at all in making those photographs. Two, if the Copyright Act says that this conduct is not permitted, it is wrong. And so often here people would refer to things like accreditation practices and insurance as requiring the very photographs that maybe, if they were problematic under copyright law, well, copyright losers. And other people having the intuitive approach to copyright. I'm sure there's something in there that makes it okay. I just can't put my finger on it. So it was quite amusing in the US to talk with people and ask them about collection management, and they did a fair use analysis on the spot. It was clear they were making up as they went along. This was not something to which people had given thought. But then in other instances, and in particular public uses, online uses, that's when the norm internalised is quite different and often results on a high reliance of permissions, particularly in Canada. So my experience in 2008 of Canadians was that I met far more people who were of the view that copyright owners should be paid except in limited circumstances. And so this stood in quite stark contrast with the CCH users' rights language. Why? Okay, here are some guesses coming out of the field work. So one is, sorry, not guesses, it makes it sound like that was random. Here's my considered analysis as to some factors that may influence why this result took place. So one is the limited case law through the 1980s and 90s. Limited, but to the extent it existed, tended towards a narrow understanding of exceptions. That the mechanisms for collective management predated the addition of new exceptions. So you had throughout the 1990s an opportunity for a permissions-based approach to copyright to get really firmly entrenched. So that means when the Supreme Court says fair dealing is bigger than what you guys thought it was, it's not just an attitudinal shift, it's actually requiring institutions to dismantle all these existing structures and put up new ones in their place. That's a really big thing to ask somebody to do. So CCH, in my view, was not incremental. There may have been previous cases that hinted it was about to happen, Tibet, the Court of Appeal decision and CCH itself, but it was not a conservative decision by any way, shape or form. The influence of the droit d'auteur tradition, especially in Quebec. I feel like for my thesis, I had 4 countries in my thesis because Quebec seemed to be a country of its own. A desire to protect Canadian cultural production, too, was mentioned by some interviewees, a concern that if you didn't remunerate creators, you would be swamped with English language materials from the US and French language materials from France, and you wanted to protect Canadian culture. A lack of confidence in CCH and its longevity could be overturned at any moment. This idea that it was out of step with existing thinking. The requirements of funders and governments, so people doing digitisation projects, many of which are funded externally, will tell you that those funders often have requirements. And those requirements don't involve exceptions, they involve clearing all rights. Often they even involve requirements that creators must be paid as well, not just that unremunerated licence is not permissible. Other reasons, we're a law-abiding country. A couple of people said that. One person, we didn't have a revolution. So, in 2009, when I gave a presentation about CCH, and I said that at that stage, if we're going to have CCH have any impact on institutional users, it's going to be an incremental process. I suggested that for academic libraries, this might take place because of resistance to access copyright licences, because that had been hinted at in 2009, and then I think since then, that's really kicked off. And I'd like to discuss that because it's something which I really want to learn more about. But I also thought, like, if there is a concern that there's not enough flexibility in exceptions, and we can debate that whether there is or is not. But let's assume that there's not enough flexibility. And that we want more flexibility, I think we need to ask, well, is there already underexploited pockets of flexibility? I mean, if people aren't exploiting CCH, do we want to have even more and bigger and bolder exceptions for them not to rely upon? So what would need to happen to change attitudes if we think that's the way we want to go? And you might say, actually, this is Canada. We don't want to go down the exceptions path. We want to go down making licensing even better. So that might be, and that's a perfectly, I don't have an issue with that contention. But if you want to make, if you say there's a problem, does the solution come from exceptions tinkering or does it come from other things? And maybe even non-legal things in terms of greater resourcing for copyright in institutions, in terms of different structures. So my final point before we open the floor to discussion that I really want to emphasise is these norms I've described are not fixed. And I've seen this in particular in Australia, so the final thing I'd like to do for a few minutes is just take you through the last 10 years in Australia in relation to copyright. No fully open-ended provision. So Australia's kind of like Canada, only better. So no fully open-ended provision. So we don't have fair use either. We do, like you guys, have provisions that are detailed to varying degrees. Fair dealing, we've had since the 1911 Act, so that's the UK Act, which was had effect in Australia. Numerous specific exceptions, including exceptions for libraries and archives, which we've had since 1968. So we're one of the first jurisdictions that I've studied to have had libraries and archives provisions. So, in the first tranche of Australian fieldwork in 2004 and 2005, many interviewees seemed to be grappling with copyright. They often reported, oh, hang on. That's telling me I have to stop quickly. It's actually perfect. 3 minutes to go before 50 minutes is up, and I'm going to get there. So, first tranche of research, 2004-2005, people are grappling with copyright. They say the law is complex, it's difficult to understand. The impact of copyright was felt most strongly in relation to public outputs, with people just like in Canada, focusing mostly on public domain material where licenses and assignments are readily available. So copyright was having a significant impact on the digitisation activities of Australian cultural institutions. There was some risk management, especially amongst people with social history collections. However, interviewees largely self-reported that their institutions were very conservative about copyright and did not want to risk the reputational and other consequences of claims of copyright infringement. Now, in 2005, there was a major review of exceptions in Australia, and this was spurred by the US-Australia Free Trade Agreement, which expanded rights in Australian law. We got term extension and so forth. And this led people to say, hang on, we got all these rights from the US, shouldn't we get an exception as well? And sort of there were questions about fair use. Big government review, and in 2006 we get some new exceptions. So they decided not to go with fair use. Bunch of specific exceptions, but then this new bespoke Australian invention called Section 200AB. Now, so this I just want to be clear, this provision was introduced with the idea of capturing some of the benefits of fair use. This is part of it. Now, for people in the back of the room, there are opera glasses under your seats so you can read the text. And this is just extracts. If I had to give you the whole thing, it would be crazy tiny. We'd need to microfiche and look at it that way. So this is the extracts. But the key things you need to know are that it only applies to 3 categories of user: cultural institutions, educational institutions, and users with a disability. Its fairness factors are in subsection 1, and they use the same language as Article 13 of TRIPS, i.e. 3-step test language. So the fairness factors are 3-step test factors. So what do you think happened in the field work? Are people relying on Section 200AB? No. So there are only very sporadic reports of reliance on Section 200AB, and this was 6 to 7 years after it was introduced. Okay? Seemed to operate as a de facto orphaned works provision, so to the extent there was some reports on reliance, it tended to be on very small collections that were orphaned, making preservation copies of them and access copies and so forth. But what was interesting was that there were a bunch of other changes, though, in the way interviewers were talking with me. They had greater knowledge of copyright law. Lots of them knew about 200AB. There'd been a greater engagement by the sector with copyright law and law reform processes, and a greater comfort with risk. And what this suggested to me, that the failure of Section 200AB is not down to lack of knowledge, lack of resourcing, lack of being ready, willing and able. It's due to manifold drafting problems. So concerns about the number of limbs to be satisfied. You've got to satisfy 1A, C, D, 2A, B, C. Then there's other things you also need to make sure are okay. So lots of limbs, difficult to explain to colleagues and management. The reports were, for any lawyers in the room, that the attempts to get assistance from external lawyers were incredibly unhelpful because the advice that came back was either ill-informed or very conservative. But what I found interesting was that they were risk managing all manner of collections. Yes, it is now a verb to risk manage a collection. So things made available online or a variety of activities. Again, not a free-for-all, but limited acts where risk management was used to make institutions feel comfortable with various activities. And what I think is interesting is they had all the factors they described with their risk management. And I'd say, yeah, but why doesn't that fall within Section 200AB? And the answer is 200AB has used drafting that just does not tie with the way that institutional staff think and the sort of understandings they have of the law. So it's incomprehensible to users and to their legal advisors. So what should happen next? Well, I think Australia should have fair use, and I think it should be modelled after Section 107, and we should repeal a bunch of the specific provisions. That's my view of things. But this is where I'd like to kick off the discussion with everyone. I've told you a bit about Australia and Canada in 2008, but hopefully I can hear your views now on Canada in 2014. So thank you very much.
Right, that's wonderful. So we have time now for questions and comments from the audience.
Quick question, when's the book coming out?
Pina asked me this before. I said when it's written. Next year, I'm hoping.
My name is David Baskin. I ran a collective for about 25 years. And I just thought I'd give you a small bit of factual background as to why the decision in SOCAN Tariff 22A was the way it was with regard to previews. When I negotiated the deal with Apple for iTunes to cover the reproduction of music as opposed to the performance or distribution of music, we simply threw in the right to make reproductions in the context of previews. Everybody agreed it had a value. We wasted no time at all in trying to determine whether the value was 0 or greater than 0. We simply recognized that in the music business, everybody will try to tell you, oh, you should let me do that for free. It's promotional. Some things truly are, some things aren't. We never disputed the idea that a 30-second or 45-second preview had promotional value, but it frankly was very much of a sideshow next to the question of what's the download actually worth, which was terra incognita at that point. So we simply said, we'll throw it in, we'll license it, let's move on to the more important discussion, and that occupied perhaps 10 minutes of a year-long discussion. I have no information as to why SOCAN didn't take the same approach. They never discussed the matter with us. I don't know to what extent the Copyright Board might have been seized of that particular story, whether they knew about it, whether they were even aware of it. But when the decision came out with the Copyright Board essentially improvising its own reasoning with regard to the use of the performing right in the context of previews, we were stunned. And frankly, I was always baffled as to why SOCAN hadn't simply thrown it in. I mean, from the perspective of authors and rights owners, the decision has been extremely troublesome.
On the other hand, what I would say that I'm at a library, so I'm a copyright officer, which, as you know, you may know that many different libraries and archives across Canada now have copyright officers where they did not have 3 years ago because of what happened with Access Copyright and various collective rights agencies. And what I've experienced is collective rights agencies have a very, very limited view of fair dealing, and you're often having to push back with them because they will come at you with fees and licenses for obviously fair dealing amount. So on the other hand, there may have been a license negotiated, but that may just have been sort of an aside. It didn't mean that that actually needed a license. So I think that licensing permission culture that's been happening in Canada is, in a way, now we're starting to push back against the collective rights agencies that have been asserting rights that they didn't necessarily have since CCH.
If I could just make a comment about that, because it reminds me in particular of some of the interviewees in the US who were talking about how do fair use arguments operate in licensing negotiations, and there was a split with some people saying that a fair use argument might be relevant to the price. So you have, here's a list of things you can do, acts that the institution thinks are fair use might be within that list, but we'll then negotiate on the price, and the price is lower to reflect the fact that we don't actually need a license for certain activities. And so that was more of perhaps a more commercial approach to fair use. Then there was other people had a view which was that as soon as you start putting in licenses things that are within exceptions, you run the risk that it all gets mixed up as to what was within the exception and what wasn't. And so other people who very much were of the view that it doesn't go on a license and we do not pay and we just hold firm on that. So it's sort of these sort of two different approaches to whether or not in the negotiations how the drafting of your license agreements actually sort of operate. But I do understand the concern of institutions and others that as soon as things are in licenses, it looks like a permission was required, and you can lose that sense of where the boundaries of the exception are.
Good talk, thank you, Emily. Just really a couple of footnotes, having seen the graph that you put up on the board about differences between US legal practice and perhaps US situational practice vis-a-vis Canada. At a legal stage, one of the things that has always struck me about American case law vis-a-vis Canadian case law, there is a much greater concentration in Canada before you get to fair dealing on the issue of substantiality, which is not there, as I see it, in as much in American law. The American cases, for the most part, that I see, they say, well, here's the copyright work, is it a fair use? There's almost no intermediate decision or asking whether there is substantiality involved, substantial infringement. And we actually, some of our case law, in fact, makes a point of that. The other aspect, which I'm not sure whether it fits exactly on the law or the cultural situation side, is in the United States, you say people were tending to make things up on fair use on the fly, and I think that's right. I think they make things up on the fly with the First Amendment in the same way. And it seems to me that there's actually a connection where you have the sort of free speech, free expression notion much more firmly built into US culture than you do in Canada. It's all very well, we've got Section 2 of the Charter. I don't think it has the same sort of institutional or social penetration as it has in the United States. And so I think those are two factors, the second one being partly legal, partly, I think, situational.
So yeah, one thing, I've got a few thoughts I might just say by way of response. First, in relation to substantial part, is that certainly my sense of the UK and Australian case law has been substantial part has just been whittled away into something that's incredibly easy to satisfy. So once upon a time, substantial part did do some heavy lifting in terms of operating as a limitation on the scope of copyright. But I at least in the UK and Australia, I don't see it as playing that role anymore, and I'd be interested to sort of talk further about whether in Canada that's different or whether it's going in the same direction, because I think that's really relevant, because you're right, you've got to have an infringement to begin with, and substantial part actually is one of those sort of principles that you could actually do quite a lot with to never have to get to exceptions at all. It's one of those an area where reform may not be required to at least have instances in which there's not conduct, I should say, is not infringing. In terms of the First Amendment arguments, when you look at the US case law, it's very rare for fair use case law to expressly invoke First Amendment jurisprudence. I think that Barton Beebe in his study, I'm now trying to remember footnotes, if I get this wrong, apologies, but I think it was about 25%. Barton Beebe did an amazing empirical study of US fair use case law. He read every single opinion and judgment issued from 1978 to 2005, and I think he's updated his study again. So it was a voluminous amount of reading. And I think he said about 25% of cases, referred to free speech arguments, but even then it wasn't really as part of a sort of standalone First Amendment analysis. And the reason why I mention that is because one of the reasons why that's put in play, that is put forward for countries like Australia not adopting fair use is, oh, but you don't have the First Amendment and that makes a difference. So there's a kind of question in how that plays out. I think that the case law suggests it's not front and centre, but your comments sort of suggest, but is it sort of lurking around in the background, and if so, what effect is it having? And to be clear too about how the fair use analysis is done, when it comes to people putting up a collection database for an art collection with thumbnails of all the artworks. That will have been thought about in profound amounts of detail. And in fact, I mean, one of the things I found interesting was when I was talking to US interviewees, they were dropping the names of these cases. That's why I've included them on the screen. They talk about Kelly and Aribasoft and Bill Graham Archives and Perfect 10. Those were the three main ones they referred to, and various others. They were invoking those and reasoning by analogy from them in a very detailed way, very thoughtful way. When it came to collection management, though, that's where I think the norm that ousted copyright was stronger, because even though you can jerry-rig a fair use analysis to explain it, it was retrofitted. They weren't thinking about copyright. So again, it's to deal with the fact that in institutions you've got these norms that don't always involve, I wouldn't say strict compliance with the law, because often they did comply with the law, they just didn't know why. So that was, so yes, it's sort of, the reasoning around copyright can very much vary from activity to activity.
Hi, thanks for that, Emily. Really interesting, and there's obviously a lot in there, so I'm not really sure where to begin. But I think my sense is, in terms of the Canadian story and understanding this sort of divergence you're seeing between what's coming out of the Supreme Court jurisprudence and what's happening on the ground, my sense is you've been kind of generous, maybe too generous, to the lower courts, the Copyright Board and the copyright collectives in your assessment of what might be responsible for this. In the sense that we've now seen CCH being sort of battied about between the lower courts. We've seen the same issues essentially being raised again in subsequent litigation and being appealed again back to the Supreme Court for the Supreme Court to say essentially we meant what we said when we said it the first time. And there's a sense that there's no reason why this would stop. Yeah. And certainly there's no indication in the current landscape in Canada that this is going to stop. And so now I think a few years ago I might have said to you, well, it's just going to take a matter of time, right? We just need to start talking more. We need to start actually exercising our rights, working our fair dealing muscles, so to speak. But now I think that there's a real sense that maybe CCH is short-lived, because who's going to be willing all the time to get back to the Supreme Court to get the dictum that they need to reinforce what we've already heard? And I think, you're speaking at York University, which is obviously on the wrong side of this question right now. And so to the extent that York University's fair dealing guidelines are actually arguably quite stringent, depending on who you ask, of course, but they were intended to be a reflection of the current state of the law, and they're now the source of new litigation. So it's almost, I can imagine why the universities might retreat to the position of saying, maybe we were right in the first place, just to be very risk averse and not to try to go to war with the copyright collectives in Canada. So I don't know, I just would be interested to hear your response. And maybe I also mentioned the board, and I think I would just say, the Bell SOCAN scenario at the board, that was their most generous interpretation of fair dealing, but of course their reading of it in the Alberta access case, the K-12 case, was very limited. And the lower courts also have been quite reluctant, I think, to really embrace the concept of users' rights and apply it boldly to the litigation before them.
Yeah, look, I think one of the questions I've had about Canada, I said at the end that norms aren't fixed, and I believe that to be true because I've seen the change in Australia. But I also believe you need to be realistic about the history and the economic and cultural context in which change is made. And I think your observation, if I understand it correctly, that perhaps just ongoing really, really fierce litigation and this debate is just going to go on endlessly if that sort of people, if it's death by 1,000 cuts to get people back to a permissions-oriented approach. I suppose the question is, if you think that's problematic, and there's some people who may say it's not problematic, that's the right way to go. But if you say it's problematic, it's then thinking, well, what's the best solution? Now, I'm not too sure that whether fair use is the best solution or more exceptions and so forth. I'm in two minds about this. And the reason why I'm in two minds is because on the one hand, I think, well, actually, maybe you need far more specific reform to law and practices. To sort of deal with this situation. It may be that you need to accept that permissions are going to be required, they're going to need to be paid for, and we need to change the ways in which things are resourced. I mean, I sort of grates with me that libraries spend a lot of time and money pushing paper around and trying to comply with copyright. I can see it as a great waste of time, but maybe there are ways we can make collective licensing more efficient, or perhaps we don't need to worry about collective licensing as much through individually negotiated licenses. I mean, there's various approaches that one can adopt, and you might say, let's stop tinkering around with exceptions and let's look to something that's actually likely to produce actual change now. But another argument is to say, no, let's look for 30 years' time. Let's have the big exceptions reform now, because in 30 years' time we're going to see the results of that. Because that's how long it's going to take to build the jurisprudence. That's how long it's going to take for new structures for management of copyright to come into place, for a new generation of people to come through who might have a different attitude to how copyright ought to be managed. So I'm very much in two minds about that. But I do think that the general proposition holds that all these other factors, what the institutions are doing, the history, the fact that the collectives really came in before exceptions were reformed with the law reform process of the 80s and 90s. These are all, in my view, having an impact now. And as I said, interested to hear, since I did my research, how people think the situation has changed, if at all. But interested in your perspective.
The only thing I would maybe add would just be both. Why not both? And so you have the legislative potential that really signals an opening up, and it gives, it gets rid of some of the potential obstacles in the way of arguing fair dealing.
What I've found really interesting about this jurisdiction is that it feels like you've had some really, from an outsider's perspective, now you may say, Emily, you're wrong about this, but from an outsider's perspective, you've had CCH and then other Supreme Court cases, legislative intervention to expand fair dealing and put in place some new exceptions, a bunch of universities deciding to withdraw from access copyright tariffs. I mean, it seems like it seems like a lot is happening, and it seems like it's almost like and I may be wrong about this, but the outsider's perspective is you've got people, judges and academics, and now members of parliament dragging users to say, we want to take exceptions seriously. But are you taking exceptions seriously? That's the sort of question I have.
Gentleman in the technician. No?
No, you actually answered my question.
Sorry, I just wanted to address something you had mentioned in your talk. I was just curious about your feelings towards this, but you mentioned that the dichotomy between a rule and a standard is a false dichotomy.
Yep.
But I was just kind of wondering if you're familiar with the Canadian UGC exception, and because I kind of feel that these new exceptions are sort of caught in between being a rule or a standard, and as a result of that are sort of useless to anybody. And the impression I got from your 200 AB example was very similar, that it provides a lot of detail but also flexibility, and sort of no one really knows which way to go on these. So I kind of feel like maybe this is a hybrid of things, whereas the dichotomy between a rule and a standard should maybe be in place so that it's it's either easier to read for somebody who's using the law, or easier to interpret for the courts. So I feel like somewhere in between, it's not really giving you the place what you're looking for.
Yeah, I think, okay, so basically I think that probably, my response to that argument would be that I wonder actually whether the problem you're describing is one of unnecessary complexity and lack of clarity. So in the language being used. So to speak to section 200AB, you can have very complex rules with a bunch of different limbs, and as long as the language is clear, then in terms of interpretation, you may need an expert to do the interpreting for you. I mean, do you want to read the income tax legislation yourself, or would you rather pay somebody else to do so? You know, you have lots of statutes which comprise lots of rules, at least allegedly, and you often need expert advice to interpret them. But in theory, at least, if the language is clear, you should be able to say with a degree of certainty, this is what the legal consequence is from this particular fact pattern. Now, I think what's happened with 200AB is that they haven't used clear concepts. They've used concepts that copyright lawyers can't decide upon. Three-step test language, it's not accepted concept from international law. Something, I find it's a sort of, you've had this situation where something that the best brains in copyright law cannot agree upon is being sent out for the chief librarian at the Wagga Wagga Public Library to have her sort of crack at what it means. And it just seems to be a dereliction of responsibility on the part of the government to actually have made these decisions itself. So I think in your case, you can have hybrid provisions that may work quite well, in as much as you might have language within a section that's more standard-like. So to give you an illustration, I'll let you say something in a moment. But in Australia, there is a provision in the Libraries and Archives provisions which permits activities for administrative purposes. It's actually quite a nice standard in the midst of these rules, because what does administrative purposes or administrative use mean? It means all manner of collection management stuff, but it's open-ended enough. It's more open-ended than the Canadian equivalent provision. It's just a nice form of drafting. So you can have hybrid provisions that work, but you seem to be describing something where there's such a lack of clarity to the language, and that may be where part of the problem is.
Well, I think it has a lot to do with legislation drafting now being specifically tech neutral. Yep. So in a lot of cases where they're trying to address a specific use of a technology, they have to adhere from actually using examples of that technology. So as a result of that, the two positions almost conflict, and you're not able to be specific enough and not able to be, open enough to actually have it have some meaning. I guess that brings me to my second question: is what is your feeling for fair dealing versus fair use? The idea of having enumerated provisions and heads under which fair dealing can occur, or having it open-ended, such as in the American example, using such as.
Yeah, I'd go with it. Look, I'd go with the American approach. I think it's better. But just to be clear, sorry, I just want to be clear about this. In Australia, I would say fair use. I don't know whether I'd recommend fair use for Canada. I mean, you've got to look at the jurisdiction and prevailing understandings and attitudes and what's been going on. But the reason why I think in Australia fair use would work is because I think that there's enough people who would be comfortable with the more open-ended nature of the drafting. Now, obviously, one approach you could say would be, let's expand fair dealing, we'll have more purposes, or you could even have the Singaporean approach of fair dealing becoming open-ended, so it becomes such as, even though it's still called fair dealing. I think, so the reason why I prefer fair use, first of all, I just think it self-updates more readily. And for institutions that are comfortable with its open-ended nature, with its uncertainty, it is a better drafting option. Another reason for fair use, though, is fair use has a rhetorical cut-through. So I was speaking to a lawyer in Australia, and he was telling me about his 12-year-old son who has a side business making YouTube videos. So if you've ever looked at those videos which are like 10 hilarious laughing goats, or those like compilation videos, his 12-year-old has a side business making these videos. And my lawyer colleague expressed concern to the son about the copyright ramifications of this little side business. And the son said, "Oh, Dad, but it's a fair use." Now, when you've got 12-year-olds able to explain that actually it's a fair use, like, it seems to me that, at least in Australia, we don't just import episodes of Law and Order and so forth in terms of American entertainment products and so forth. There's a whole bunch of other stuff coming with it. And when fair use is seen as different from the existing. And so if you want to change norms, something that screams, this is different from what's gone before, is really important. And in Australia, we don't have anything equivalent to the CCH decision. So if you want to change interpretive practices of judges and really encourage that shift and say, yes, you can think differently, fair use might be the way to really very quickly hone in on that idea.
Yeah, I just wanted to ask you a question from the standpoint of political economy. It's kind of Orwellian. But we have a situation now, if I'm interested in researching Justice Felix Frankfurter, for example, and I know that he's written articles in the Harvard Law Review. Now, to get access to that, I belong to a community, and I pay a fee to that community, which is the university community. And they pay a fee to the digitalizer of the Harvard Law Review and the Yale Law Review, etc. So there's now an impediment or a barrier to people that want to do this kind of research. We've gotten away from the idea that the creator has a property use in what he created. The digitalizer has an interest in the energy and the time that he's taken to put that stuff online. But essentially, they act as gatekeepers. If you have somebody who's doing legal research who's not part of that, legal history, then they're excluded from that whole political economy now of digitalization. And this is where it seems things are going. Because even if I went to Harvard Law School itself, it's unlikely I'm going to be able to get that written copy of the Harvard Law Review, because it's probably digitalized as well in Harvard. So I'd like your comment about that.
I agree with the concern that you've expressed about the movement of collections, and in particular library collections, from being open to all, largely because people actually went to the library and pulled the thing off the shelf, to something which is in digital format and is now appearing in subscription databases which have limits, and often they're quite, there'll be rules about how many users you're allowed to have on board at any one time, and talking to various librarians that if you want to add more users, then the fee just goes up and up and up. So difficult decisions need to be made about who can have access, and often in the academic session, I think in the academic world, it becomes you need to be faculty or a student at the university, or maybe certain, I think at Oxford, even special guests, it can be difficult for us to get guest access to the databases because that's contrary to the license. So I agree with your concern, and as I'm sure you're aware, there's obviously an open access movement seeking to encourage people to publish in open access journals and so forth. But I'm not too sure that I can say much more than I agree. And even in projects sort of like the Google Books project, which I spoke to people about, but only indirectly because there are confidentiality undertakings, so people there's only so much they could say. But from public knowledge, institutions who participate have the benefits of having all these resources digitised, but then there's limits on how they can then use the digital copies. And so it seems like a great project, but you've got this propertisation occurring alongside that. So it is something about which to be aware. I'm not too sure I can say anything further than that. I share your concern.
The book is on the shelf at Harvard, and it's on the shelf at Osgoode Library as well.
I have just two factual comments to make on something you said earlier, and then I will make a comment and ask you a question which is not intended to be rhetorical on that. My first comment is that the 2% amount, I think I have tracked to the UK Act, where in fact long ago, and I think it's still there, that collectives were required, if they were licensing educational institutions, were not allowed to give less than 2%. So I think that's where that came from. The only other time I've heard the 2% mentioned in discussion in Canada on copyright reform, which I've been involved in for a very long time, was in the discussions before the exceptions came in 1997 or 1998, where the lawyers for the government who had convened roundtables on what educational exceptions and library exceptions should be did mention 2%. Since that time, those same lawyers have taken quite different positions. But anyway, those are just the other fact is with respect to the Law Society case, and I don't know if there anything really turns on this or not, but that access to law policy that was developed by the Law Society during that library, during that period, actually was documented and put in writing for the first time during the litigation. So those are my two just factual statements. I hope they're correct. I think they are. My comment is, you mentioned a number of times the cultural and economic context, and you talk about behavioral norms, but your argument doesn't really seem to focus on that very much. Now, I agree with what David said about substantiality. I very much agree with that, and that is always going to be a judgment call. So I'm not denying that. That's important both for users and for copyright owners, and those are the two groups that have a basic interest in the Copyright Act. So here's my comment. Universities are sort of at the center of the cultural elite, or academics are the center of the cultural elite of this country. The universities are centers of culture. Academics are writers. They contribute to that culture in two ways. They're writers themselves, artists themselves. They do things which are a central, important part of our culture. And they also comment on and make us think about the culture that is contributed by other writers and artists and so on who are not salaried, who are outside the university environment. Part of the context is that the artists in this country, and I'm talking about artists in a very broad sense, do not do well. There are a few stars who do brilliantly and make a lot of money, but most people who are professional artists barely make enough money to support themselves. Best strategy is to be married to somebody who has a job, a job outside that cultural area. So my question to you is, why is academia, why are the people who work in academia the leaders of the charge to try to change the behavior of everybody, of people, of upcoming generations, students, et cetera, why are they encouraging this everything should be free mentality, pushing the limits of the exceptions, pushing the limits of fair dealing, fair use? This seems to me that there should be some element of social responsibility in this, and the universities should be thinking about the importance of culture. And I just, I'm baffled by why this push is coming from the professoriate, especially from the legal professoriate.
Well, perhaps I could tell you. I am a writer, I am a user, and I believe I'm socially responsible. I'm socially responsible to get the law right, and I try to do that. The phenomenon you talk about of starving artists is not a Canadian phenomenon. It's a worldwide phenomenon. No one makes money as an artist unless you rightly say they have a working partner, are stuck in a university, and are able to do this as a part-time job, or that's about it, or they are a star. Right? And of the stars we talk about are 0.00 that we read about all the time, and we think we can all be like them, but we never are. So I don't see myself, or I don't see the academics that are, as you say, leading a charge. No one's leading a charge here. Some people are trying to honestly see the world as it is, or as they believe it ought to be, and they believe that this is the way in which the Canadian culture can flourish, or not just Canadian culture. So I mean, I don't have any problem with copyright owners or authors having their point of view on this, and I have a point of view too. I quite like to see my royalty check now and then, and go and have a rather small hamburger on the result. But that's neither here nor there. unless if you're trying to improve the lot of freelancers, struggling artists, struggling authors, the copyright law is a very small area of the mechanism that is available there. There are a lot of other things that need to be done before you can do that. You can see that working in patents and all sorts of areas. You can make the rights stronger. You can get everything you want to do through the copyright law. Will you get better books? Do you get better creativity? Yes, you get more goat videos. But do you get anything better? Are people making more money out of it? I think you may make more money out of it with whatever rights you give them or not. I suspect practices work much better than law does here. So I repudiate your suggestion that academics somehow are socially irresponsible people any more than anybody else in the society is.
One thing I didn't actually say, which was just, I enjoy your book, David. Use it. But one thing I didn't say is that the danger in this that I see is that, in fact, and I shouldn't have used the word leading the charge, but you are trying to affect, it is trying to influence how people behave in the universities, telling people what they should do, giving guidelines to the universities, telling them what they can copy and what they can't. This is gradually changing custom, and we know that the courts, when they actually change the law, we have open-ended copyright laws in many ways. I mean, fair dealing is open to interpretation, and when you leave things open to interpretation, I think I'm right to say that the courts are much influenced by what people actually do. And drafters of legislation are very influenced by that too, because they don't want to see a nation of lawbreakers. Anyway, that's, I've just add that little thing. So I think that, and I would also say again, I'm really surprised that there isn't a movement from the universities as well that is, in fact, saying we value culture, we are worried about market impact. That was sort of touched on in the Law Society case, but it was kind of a bit neutral. Anyway, that's what I have to say, and I'm very disappointed in some colleagues of mine, some of whom are good friends, and I respect their views, but I do think we have a real problem, and it's necessary to look at some broader cultural and economic issues before one tries to nail what are the appropriate limits to fair dealing to the ground.
So if I can just make a couple of points by way of response. I think I would align myself with a number of things that David has just said. And I think that to the extent we are concerned about the situation of creators, I don't think copyright's a particularly good mechanism to deal with that, because copyright has always rewarded the commercially successful more than the less commercially successful. It's not a wealth redistribution device. It very much follows popularity and trends and so forth. So I think that I would agree with David, there are other things that one might want to do to improve that situation. I'd also emphasise too that I think to the extent that some of the content industries complain about current attitudes to piracy and downloading and an expectation that everything's free, I think my sense is that there are other changes to the content industry which are having a far greater impact than what users are doing in terms of their expectations and activities with piracy and so forth. And to illustrate what I mean by that, you look at, for instance, the role of legitimate market players like Amazon, like iTunes, in changing the way in which content is made available. Netflix and Hulu, and in terms of audio-visual works, there's just changes in the way in which copyright works are distributed. And a lot of these threaten existing models of how you commercialise copyright works. So if you've been used to selling cable television rights, so you have your television program and you package it off so that various cable channels around the world can broadcast it. But then you've got this new idea, which is that actually people want to download episodes on demand and they don't want to buy a package, they want disaggregated content. And then people pop up, legitimate market players who will disaggregate content and sell things for more cheaply and so forth. That's having, to my view, a bigger impact, at least on the entertainment product sort of side of things, than piracy, or at least as big an impact. I'd probably say more. And so I think that people can get sort of fixated on particular issues when in actual fact there's a far broader change taking place. And in terms of sort of the models of successful content at the moment, the internet may have been a democratizing force in terms of more Robin Thicke parodies, more goat yelling videos and so forth. But the blockbuster model is as strong as ever. And in fact, it's getting stronger. And that's the model that's coming to dominate, that you have a sort of handful of very powerful players who are involved in the production and marketing and distribution of copyright works, as I said, in the entertainment sphere. So one of the reasons why I'm comfortable about really pushing an agenda for exceptions that are meaningful is that I actually don't see copyright owners and creators as the same group, and I think a lot of things that are done supposedly on the behalf of creators are actually done just to further the interests of big corporations who make money out of exploiting artists. So that's my own viewpoint. But I don't disagree with your premise, though, that we need to protect really important forms of creativity. I personally think that exceptions can facilitate that to the extent they facilitate new authorship. So I think exceptions are author protecting because they allow new creatorship. But I think that I don't disagree that there are instances where creators should need to give permission, where they should be paid, where they need their moral rights respected. So I do not disagree with that premise whatsoever.
Okay, well, I think it's time to give thanks to you. So if we give a big round of applause.
Oh, thank you so much.
So thank you so much.
Oh, thank you. And can I just want to say two things. One is I just want to plug again the Oxford IP Moot. It's going to be fantastic. So hopefully we'll have even more Canadian teams. They do great and they're fun to have around. But secondly, I am going to tout for business. I'm updating my field work for my book. So I want to speak with more Canadians about what's been happening. So if you believe you are a relevant informant for my study, I'll be here for another couple of days to meet with people face to face, and then I'm going to be using this great innovation called Skype and the telephone to continue talking with people. So if anyone wants to contribute, please let me know and I can give you information about the study. It's just having a chat with me. It's all anonymous. Your name will not be in a headline as being a rampant copyright infringer or hating such and such. But thanks very much for your questions and participation.
Thank you.